Welcome back to Canadian Justice, where we're discussing the federal plastic ban, the ban on single use plastics, how it has been overturned by a federal court. Now, Brett, I think environmental protection, most people know that this is a shared federal provincial responsibility. But I think a lot of people can get confused when an issue falls within federal or provincial jurisdiction, especially because all kinds of environmental issues, even if they start in one province, can cross borders into another province. What did the court say about these jurisdictional questions in this plastics case?
It was mostly confined again to the criminal law power, and again, the the underlying concern from the court is it doesn't want the criminal law power to inadvertently, quote, eviscerate a provincial head of competence or head of power. And so, similar to POG, which was an issue in the Impact Assessment Act
That's
reference, and
peace, order, and good government, a part of our
that's right.
constitution.
And so it's going to allow some intrusions, incidental effects, they call them, but it's really when it starts to cross that line and in pith and substance to appear to be regulating a matter under the other head of government that we run into problems.
Kaitlyn, anything that you want to add there?
Yeah, I mean, I think the challenge with plastic pollution is that, not only once it's released into the environment does it flow across boundaries, into different rivers and streams and through the air, it also enters the bodies of animals who themselves don't reflect boundaries. And so, it can really cause great distance. And that's why it is a national and a global crisis.
Now, Brett, I think there's adding to some of the confusion that people have about when an issue about the environment falls within federal or provincial jurisdiction are some recent cases like the Impact Assessment Act, the greenhouse gas emissions case. Um, and I'm wondering, where does this case about plastics fit into that debate? Does this add any clarity about when an environmental issue falls within federal or provincial jurisdiction?
So, because the case was dealing mostly with the criminal law power, it has some utility going forward, I think, for cases like the clean electricity regulations, oil and
Exactly.
gas emissions cap.
Because I think that the
Um,
clean electricity regulations that are being proposed, that is being proposed partly on the basis of criminal law power. Is that right?
Ultimately, we'll have to wait to see, how Canada would argue that. But I think most commentators and academics are speculating that it likely will be a criminal law issue, as most SEPA issues tend to be under the criminal law. That was, all the way back from Hydro Quebec, more recent cases like Syncrude. So I think we're all sort of waiting eagerly to see how this is going to have a ripple effect through future challenges dealing with SEPA.
Caitlin, is there anything you want to add to this about where the criminal law power in future cases, how this decision on criminal law power might apply in future cases, whether it's related to the clean energy regulations or the proposed emissions cap, or maybe in other areas of law?
Yeah, absolutely. It'll be interesting to see, and it will be interesting to see what happens, of course, on appeal. So, I think the story is not over yet. But I do think the door is still certainly open to using criminal law power. Of course, we know that the criminal law can be used for matters of environmental protection and for matters of animal protection, which is one of the arguments we made here. But I think the court here was signaling that they will take a hard look at the reasoned apprehension of harm to ensure that there is a proper use of the criminal law power now and in the future.
Now, Brett, another issue in this case was that the Minister of the Environment refused to allow a board of review to assess the alleged risks associated with plastics, even after the plastics industry objected to the ban. What is the purpose of that review, and what did the court say about the minister's refusal to allow one in this case? We've got about a minute.
Yeah, I think that there was some significant opposition to the order, and there is a rather discretionary mechanism in the act allowing for the minister to call this board of review, and the minister ultimately didn't, and the court simply held that this lacked transparency, and the quote is completely renders the BOR decision unreasonable, right? So it was really a transparency thing that trickles from the old Vavilov case or the new Vavilov case on administrative law grounds.
Now, we've got to go to commercial break now, but I want to discuss when we come back what this decision means for the future. I mean, am I going to get plastic straws back? Am I going to get shopping bags back? Or is it going to depend on where I live? Or is it going to have no impact at all? We will be right back.